Hello everybody. I'm going to kick off, and as people join, we will let them in the background. So firstly, thank you very much for coming to this presentation. My name is Mike. I'm one of the partners here at Buckworths. We're going to talk about sort of the legal essentials, so the key things that you need to think about as you sort of set up your food and beverage business. Before we go into the detail, a couple of practical points. First thing is that we are recording this presentation. You're welcome to turn on cameras if you want, but also feel free if you don't want to. We'll take any questions at the end. If you've got questions, feel free to pop them into the chat as we go. And then when we get to the end, we will obviously answer all of those for you. We will send slides at the end of the presentation, so they will come across to you. If you signed up through Eventbrite, that should be automatic. If you signed up through other platforms, then feel free to pop us an email just to make sure that we've got your email addresses. Wonderful. All right, before we start, a bit about us. So we are a firm of solicitors. We work exclusively with startups and high growth businesses. A huge part of our practice is actually working with food and beverage businesses and FMCG businesses. So in terms of sort of percentages, I would say it's roughly about sort of 30% of the business is food and drink. There's about 30% which is tech and all that stuff. And then the balance is a weird mix and match of other stuff, but actually primarily sort of restaurants, hospitality. We work, as I said, exclusively with startups. So it's everything really from the very beginning. So pre-incorporation, in practice, all the way through to exit. Most of our clients are sold by around about 150, 200 million. That tends to be about the top end for exit valuations. But true to say, lots and lots of our clients are sold at lower valuations and sort of levels before that. So in terms of what we're covering, and by the way, before I start, I should say, if any of you haven't had your dinner yet, I apologise. There are lots of pictures of pies as we go through this, so try not to get too hungry. Maybe it will inspire you to bake a pie later this evening, but yeah, lots of pie imagery as we go through this. This presentation then is really sort of set into or split out into three bits. So we have the first section that we call baking the pie. So look, it's a pretty simple metaphor. It's the idea of sort of getting the business sort of up and running, that sort of pre-launch stuff that you need to do. We're then looking at slicing the pie, so very much thinking about ownership of the company. So thinking about founders agreements, investments, getting external investment, and then options to incentivize key members of the team. And then the final piece, selling the pie, is really thinking about, you know, who you are going to be selling your product to. So consumers, retail and wholesale, and then just at the end, some thoughts about what you need to be thinking about today in order to prepare you for selling the business as a whole. So to start at the beginning with baking the pie, I wanted to talk first about trademarks, because I know that this is something that comes up the whole time when we work with clients. So what do I do to protect my brand, perhaps my slogan? The answer is you get a trademark. So if you think about trademarks, they're all of the sort of brands and slogans that you see in the world around you. So, you know, Mars on the food side, Tetley, they are trademarks. To get a trademark, what you do is you go to the intellectual property regulator in the jurisdiction in which you want the trademark. So if you're thinking United Kingdom, you're going to the intellectual property office, and you are filing for a trademark. And what that trademark gives you is it gives you a monopoly right to use the brand in the course of trade in respect of specific goods and services. And it's in that jurisdiction. So if you have a UK trademark, your brand is protected in the UK. It isn't protected in the US or India or France. If you want to get a trademark and you want to get protection in other jurisdictions, you have to file for a trademark in those other jurisdictions. What I would say for most of you, when you start, a UK trademark is probably what you need. For most of you, your first jurisdiction is going to be the UK. As the business expands, you can then sort of expand from there and expand your trademark portfolio. It's super important that you apply for your trademark in the right classifications of goods and services. So if you are, and let's just go with pies because it seems to be the theme of this presentation. Let's say you're going to sell apple pies. you would want to make sure that you have a trademark for apple pies, desserts, pies, those sorts of things. You might say to yourself, look, the plan today is to sell apple pies and desserts, but maybe in the future, I might want to do other types of pies, so perhaps meat pies, or you might want to do other things with apple juice. So think creatively about where your business is going to go and try to get a trademark to cover all of the ways your business will expand today. Why? Because once you've applied for a trademark, you can't change it. So if your product listing expands and you actually need to get trademark protection for other products that you're selling, you're going to need to get a new trademark, and that has a cost associated with it. So within reason, try to think broadly. Do you need to get a trademark today, or can you get it a little bit later? So is it something you do before launch, after launch, when to sort of fit it in? What I would say to you is this: the most important thing you can do is actually search for your brand on the trademark registries. So it's not actually filing for the trademark, it's doing a search and seeing if there are any other businesses trading under the same or a similar brand. That's massively important, because if there are other products in your space that have the same or a similar brand, they can actually stop you trading under that brand, and they could block a trademark when you come to apply for it. So the most important thing to do is do that search today. You can get a lawyer to do it for you, or you can do it yourself. If you want to do it yourself, you go to the IPO's website, go to their search function for trademarks, and then run a search for your intended brand. You can do the same in other jurisdictions as well. I would go to WIPO, WIPO, which is the World Intellectual Property Office. They have a search functionality as well. You can search for your brand there. So that's the most important bit. In terms of actually applying for the trademark and getting protection, you want to do it as soon as you reasonably can. So once you start trading under a brand, you get automatic protection under English law within the UK for the intellectual property in your brand. And it's under a concept called passing off. So you have that protection without a trademark. What a trademark does is it makes it much easier for you to secure protection if somebody infringes your trademark. So my comment would be, get it as soon as you reasonably can, but it's not absolutely vital that you get it before you start trading. And the final one, can you do it yourself? The answer is yes, you can. There's a very easy form that you can fill in. The only cautionary point would be, trademark law is actually quite complicated. You can apply for a trademark yourself, and it can be opposed, it can get refused by the regulator. When actually, if a lawyer had done it for you, that wouldn't have happened, or that it wouldn't have been as problematic if it had happened. So it's worth talking to a lawyer, getting their view on the risks and what can go wrong, and then sort of taking a view whether you want to do it yourself from there. The next topic I wanted to talk about was packaging and labels. So when you start trading, when you start selling your product, you are going to have to ensure that you have compliant labeling on that product and legally compliant packaging. Now, the bad news is that labeling obligations and packaging obligations are different around the world. So if you're selling products in the UK, the labeling obligations you have to comply with will be different to if you're selling products in the US. Currently, the labeling obligations are relatively, very, very similar between the UK and Europe. But because of Brexit, we are now starting to depart a little bit from EU rules. So you do need to be aware of the jurisdictional differences. What you are looking at doing is making sure that your labeling is compliant and has all the right information on it. So thinking about, what are the ingredients, what are the allergens, you have to have a barcode, it has to be a certain size, you have to have a batch number. So making sure you understand what you have to do and you comply with it. The best place to go to figure this out is actually the gov.uk website. So if you go on there and you Google sort of labeling obligations gov.uk, there's some really helpful guidance about what you need to comply with. It is very complicated, by the way, and it will take a bit of time for you to get your head around it, but super important that you have a look at that. If you're working, and I'm sure all of you will be, with a manufacturer, they should be getting this right for you, but do not assume that they do. So even some of the bigger manufacturers, they should know what they're doing. They probably do, but they do make mistakes from time to time. And what you will find in your manufacturing agreement is a provision that says it is your responsibility, not theirs, to ensure the packaging is right and that the labeling is correct. So always, always, always check and just make sure there's been a sanity check before you start clicking a button and approving label designs and all this kind of stuff. The second point on labeling is actually around the little icons that you see on packets. So most of the icons are actually subject to licensing, and you have to purchase a license or be a member of a scheme to use them. So think about sort of the vegan, the fair trade labels, all those sorts of things. You can't just chuck them on your packaging, on your labels. You have to have a license to do that. So understand what icons you want to put on your labels and then figure out what it is you need to do to be able to do that. Just as a word of warning, some of them take quite a bit of time to secure, so you do need to sort of pre-plan this bit. And then the final thing I wanted to flag, and it isn't strictly related to labeling, although sometimes it can be, you must not make misleading or unlawful marketing claims. So the ones that tend to trip people up, the first one are medical claims. So, you know, this product will reduce your cholesterol. If you want to make that claim, you must have scientific clinical evidence that your specific product reduces cholesterol. It is never, ever good enough for you to include an ingredient in your product that ingredient in and of itself has been shown to have medical benefits. That's not enough. If you want to make a medical claim about your product, you have to have done the testing and the scientific research to ensure that your product meets that medical claim. So massively important. The fines for getting this wrong are very, very significant. So you must be very careful about medical claims. The second thing is comparative advertising. You know, it's a fascinating read actually if you're into this kind of stuff, to read some of the regulator, which is the Advertising Standards Authority, some of their guidance on this. There's case after case after case where businesses get this wrong. And by the way, it's often quite big businesses who get this wrong. But if you want to say, as a really banal example, that you are the best of this type of product, you need evidence to support that. And you need to have some sort of quite clear language around what we mean by best and how that conclusion has been derived. So anything to do with sort of medical claims, comparative advertising, those sorts of things, speak to an advertising expert, whether it's a lawyer or a consultancy, but make sure you're getting that stuff right. Third topic on this sort of initial stage is around manufacturing agreements. So all of you creating a product are going to end up working with manufacturers. There are loads and loads and loads of things that can go wrong with manufacturing agreements. Some of it is relatively obvious, and you can probably sort of figure it out yourselves. Some of it is actually a lot more nuanced, and you really need to be speaking with and working with lawyers who understand these agreements to ensure that you get it right. So I've listed out some of the key things that you will want to be thinking about as you sort of negotiate your manufacturing agreements. So the first one is ownership of intellectual property. So we're not necessarily here talking about your brand and your logo. What we're thinking about is things like formulations, recipes, that kind of stuff. So when you work with a manufacturer, what they will generally be doing as a preparatory step before they actually start manufacturing your product is they will create a formulation that works for their machines. And so what we're thinking about is, I don't know, if we are, what should we create? So let's go with a Meghan Markle approach. We're going to create some lovely jams. So in order to manufacture the jam, there are a bunch of ingredients, right? So there's going to be some fruit, there's going to be some sugar, there's going to be a bunch of preservatives perhaps that go into it. The manufacturer will generally do the work to figure out how that will fit together, obviously with your input. And they will come up with a formulation that works for their machines and works from their perspective. it's important, if you can, that you own that formulation. Why? When you come to raise investment from angel investors, you will probably be using two tax relief schemes called SEIS and EIS, and we're going to talk about investment towards the end. Depending on how you navigate those schemes, it may be more or less important that you own this, all of the material intellectual property used in your business. So there's a couple of ways of sort of qualifying for the schemes. Some of them it doesn't really matter, others it does matter a lot. So owning that IP is actually quite an important point. Sometimes what you will find is that manufacturers try to link ownership of IP with minimum order quantities. And what they'll say is, at the point that you have ordered from us X number of units, we will then transfer intellectual property to you, or we'll allow you to buy it at a certain level. You want to try and break that linkage if you possibly can. It's not logical, actually, it's not really rational. And you don't really want to you don't want to have your IP held hostage against a minimum order quantity. In terms of minimum order quantities, it is what it says on the tin. What I would say to you is, for obvious reasons, they want to be as low as possible. The biggest mistake that we see people make on the manufacturing side is they get massively over optimistic about the minimum order quantities, and they find that they can't meet them. Or even worse, sometimes they find that the initial product that they start working with the manufacturer on isn't quite right. It goes into the market, they get it into stores. The feedback is, we like it, but we think it should be more like this, or it should change slightly. And you can be stuck into minimum order quantities on your old product when really you want to pivot to a slightly different new product. So be really careful about minimum order quantities. Obviously, you need to understand your financial terms. And to a degree, that's sort of a statement of the obvious. But think about when you're going to have to pay. Is it in advance? Is it on delivery? Is it 30 days after delivery? For new businesses, a lot of you will find you're having to pay a chunk up front. So just think about that and think about how it impacts on your cash flow and how you're going to fund those obligations. Risk and insurance is super important, and it's something that, from my perspective as a lawyer, is almost obviously the most important thing, but I think sometimes it gets missed in manufacturing agreements. So let me just give an example. Your products are recalled because you discover that there are little bits of metal in the jam, or I don't know, the wrong chemical has been accidentally put into the product. That is going to cost you an awful lot of money, because you are going to have to claw back a whole bunch of product that's been pushed out to loads of potential retailers. You're going to have to take it back. You're going to have to refund the retailers, and you're going to have to not sell that product. There is a cost that you will suffer as a result of that. And it isn't just the lost sales. It is potentially compensating retailers, potentially compensating consumers, even paying fines for having non-compliant products. You need to make sure that if that happens, you have direct recourse against the manufacturer. And so what we're looking for in the manufacturing agreement is a couple of things. One, clear standards against which they are manufacturing, so that you can show they breach those standards. Number two, what's called an indemnity. So if you suffer loss as a result of the manufacturer's breach, you can reclaim your loss pound for pound from the manufacturer. And then in the background, you need to make sure the manufacturer is good for the money. So you need to make sure they've got a decent insurance policy with a nice big liability cap in place, and that they haven't limited their liability under your contract at a level that means you can't recover from them. That's super, super important. If you get this wrong, your product liability insurer is going to end up paying out, and that's going to cost you money. It's going to make your insurance premium bigger, and it's going to mean if there is a claim, then there's a very nasty increase in your premium going forwards. So you really do need to think about that risk and insurance piece. Sometimes clients will want to get exclusivity. Now, manufacturers generally are not going to want to give you exclusivity for a particular product. But if you're doing something particularly innovative, maybe, big question mark, but maybe you might be able to negotiate a form of exclusivity. So as an example, we have a we have a client who's making a product, and they're making it out of a very, very specific and not very commonly used type of grain. That grain is actually relatively hard to come to get your hands on, and it's produced in a specific part of Europe where there are sort of limited supplies. So what they have negotiated with this particular manufacturer is the manufacturer will not create any other products out of this grain. And that's massively important to the client. And you can see that in this instance, because it's a specific type of grain, it's actually relatively unproblematic for the manufacturer. So think about exclusivity and whether there's a way of framing it that doesn't negatively impact the manufacturer. But just be aware, lots of manufacturers just won't agree to them. We sort of touched on this in risk and insurance, but think about returns. If you're going to have to do returns, there's going to be a cost associated with that. Understanding who is responsible for compliance with regulatory regimes is super important. So this goes back to things like the labeling. Often manufacturers' agreements or manufacturing agreements will say the manufacturer is not responsible for regulatory compliance. So it's your responsibility to sign off labeling. It's your responsibility to make sure that all of the foods, all of the ingredients in the product are allowed to be sold in the country in which you're selling it. Ideally, with most manufacturers, you want them to be on the hook for this, because where things go wrong with food products and drink products, it actually tends to be the regulatory compliance. So you want to try and make sure your manufacturer is on the hook for this compliance and not you. Either way, you need to know who is responsible. And if you're responsible, you need to make sure the right experts are checking this so that you don't make mistakes. And then the final point on this is something super silly and super simple, but actually causes a disproportionate number of problems. If you are moving stuff across a border, you are going to have to provide a significant amount of information to the border controls, the customs people, about the products, where they've come from, how much they cost, and what's in them. That will require that you get that information from the manufacturer. And generally, the manufacturer will need to provide you with a whole bunch of paperwork, a whole bunch of information. It's a really good idea to ensure that in the manufacturing agreement, there is a schedule that lists out everything the manufacturer will give you in terms of paperwork. Because what happens if you don't do that is they don't give you the right stuff. You get to the border, it gets stopped. Maybe, maybe there's a whole bunch of fines imposed on you and customs duties imposed on you that wouldn't have happened if you had the right documentation. So trying to figure out what it is you need and get that built into the manufacturing agreement is always a good idea. So that covers the sort of initial bit. We're now going to think about what I've called slicing the pie. So ownership of your business and how we make sure that the right protections are in place for shareholders, investors, and all those sorts of things. So I wanted to start with founders agreements. This is an area where, unfortunately, we see lots and lots of problems. And bluntly, the reason we see lots of problems is because there isn't a founders agreement. There are three key areas that have to be addressed when you have co-founders. Worth saying, there's lots of other stuff that can go into founders agreement, much of it very important and very useful. But these three things are the most important things, and the things that if you haven't covered off, there's a reasonable chance you're going to run into a problem. So the first one is ownership of intellectual property. So look, if your co-founder, let's say, creates your logo for you, or they create your formulation, or they deal with your labels, unless they are an employee of your company, so paid under PAYE, they own the intellectual property in what they've created and not you or your business. If they then leave, for whatever reason, they take that intellectual property with them, and potentially they can stop you using it. So as a very, very basic first step, you need to make sure that your co-founders, all of you, have signed an intellectual property transfer provision that moves intellectual property created by the co-founder to the company. So now, if that's been signed, the logo created by your co-founder belongs to your startup. And if your co-founder leaves, the IP, the logo, still belongs to the startup. Within a properly drafted intellectual property transfer clause, there are a couple of additional things that are important. So there's what's called a waiver of moral rights. Very simplistically, the creator of intellectual property has the right, amongst other things, to stop an intellectual property work or copyright work being amended. So your co-founder created the logo, you've been transferred, or your company's been transferred the intellectual property rights, but if you haven't waived the moral rights, you can't change the logo. So there's always a waiver of moral rights. And then we would quite often build in a provision that says if the co-founder leaves the business, they cannot make use of the intellectual property because they don't own it. So that's the first thing that needs to go into a founders agreement. Second thing is really around those sorts of restricted covenants. So thinking about what the founders can and can't do during their involvement with the business and then after they've left the business. So we would want to see a confidentiality provision. We're not going to disclose confidential information of the company to other people. And then we would want to see non-competes and non-solicits. So we are not going to set up a competing business selling the same products whilst we're involved in the company and for a period of time after we leave. And we're not going to nick staff and nick customers, suppliers, retailers we're working with for a competing business. So this stuff is conceptually very straightforward, but it is massively important that it's put into a founders agreement and it's drafted in the right way. Worth saying, restricted covenants are, as I say, conceptually straightforward, but they're not necessarily enforceable if they're not drafted correctly. So ideally, you want a lawyer to draft these things for you. And then the final thing that we worry about in respect of founders and co-founders is the equity. So in all likelihood, our co-founders will have been issued with all of the shares that they're going to get up front soon after the company was incorporated. And the reason we do that is because every time shares are issued, there is a calculation for tax purposes. And if the shares have a value when they're issued, then there's going to be an income tax liability for the recipient of the shares. So what we do is we issue shares to our co-founders up front when they have no value, and therefore there is no tax liability. The problem comes if the co-founder then leaves. So you might think to yourself, I set up the company on the 1st of January. It's now the 22nd of July. My co-founder's just quit and walked away. I can take the shares back off him because he's not contributed properly and won't be contributing going forwards. Sadly, you can't. The only circumstance in which you can do that is if there is a written agreement allowing it. So what we want to see in a founders agreement, or potentially in the articles, is a vesting mechanism that says we founders get our shares issued up front, but we're deemed to earn them over, say, 4 years. If somebody leaves before the end of that 4-year period, we're going to take the number of shares that they haven't earned off them. So, for example, if I leave after 2 years, I've earned half my shares, I haven't earned the other half. There's a mechanism in place that allows the company or the other co-founders to take half my shares off me. So that's the vesting mechanism. The most important bit, and the bit that we routinely see people getting wrong, is the actual mechanism to take the shares back. So just because you've got that vesting bit in there that says the shares are deemed to be earned over 4 years doesn't mean that you actually have the ability to take the shares back. The reason for that is to transfer shares, you have to, at the very least, the person who's transferring the shares has to sign a stock transfer form. And if they refuse to sign it, you can't get the shares off them, right? So what we do is we build into the documentation a power of attorney that allows us to sign that stock transfer form on behalf and in the name of the person who's losing their shares. We also build in a mechanism that allows us to convert the shares that they are losing into what we call deferred shares. And deferred shares are shares that have no value. And so rather than transferring shares, we sometimes convert them into deferred shares and thereby deprive the leaving founder of the economic value of those shares. The reason we do that is sometimes a share transfer can generate a tax liability. If we defer the shares instead, it doesn't generate a tax liability. Short version on equity. It needs to be documented right, and it needs to be done properly in order for you to be able to get unvested and unearned shares back. So all of that generally goes into a founders agreement or articles that are put in place at the same time. So make sure that stuff is done correctly. Linked to that, I wanted to talk about sort of general team incentivization and how we do that. So there are really sort of three ways. The first is exactly the same as founders. So if the company hasn't raised investment, hasn't got any material value, we can potentially just issue shares outright to our team members and subject that to the reverse vesting. But if the shares have got a value, as I said a second ago, and we issue shares to somebody when they have value, they're going to get hit with a tax liability. The circumstances when shares would have value are really twofold. The first is when you've raised investment, and the second is if you're trading, particularly if you're profitable. So in those circumstances, rather than issuing shares outright and risking a tax liability for the recipient, what we might instead do is grant options. So options are a right to acquire shares in the future at a pre-agreed price. And conceptually, there are two types of options. If you are granting options to employees, so people paid under PAYE, there are some tax advantaged ways of doing this. And the main scheme that we use is called EMI, so Enterprise Management Incentive Options. And what they do is they essentially give the employee options and actually eventually shares when they exercise the option agreement at a preferential rate on a preferential tax treatment. If you're granting options to somebody who isn't an employee, so advisors, anybody else really, then you're going to be granting them unapproved options. And those are just options that don't have a tax advantage. I think the important point to take away from this sort of slide is before doing anything with equity, you need to understand the value of the shares that you're trying to distribute. And if you have raised an investment round, just talk to a lawyer on it, because the company will definitely have value, and there will definitely be a tax liability if you issue shares to people outright. Final bit about slicing the pie is really around investment. So some of you will self-fund your startup, and will do that incredibly successfully. So you will put a bit of money in yourself, you will get your products launched, you'll get them into stores. Maybe at some point you will borrow money in order to fund your scale up, but essentially you'll go all the way through, or most of the way through, without raising external investment. If you are able to do that, good for you. It's in many ways, it's actually the best way of doing this, because you keep the equity in your business, you don't give it away to investors. For most of you, however, you're going to be raising investments at some point. In terms of source of investment, conceptually, you've got, and by the way, I'm talking about equity investment here, so selling shares in your company in order to raise money. You've really got sort of two sources of funding. The first is angel investors. So these are relatively high net worth individuals who are generally looking to get some tax relief using the two schemes on the screen there, and also to sell their shares at the end of the day at a significant multiple of what they bought them at. You've also got funds all the way from sort of early stage seed funds, SFC Capital, Ascension, those sorts of people, all the way through to the bigger VCs. It doesn't necessarily matter which route you go down in terms of who you raise from. The commercial terms will look a little bit different depending whether it's angels or VCs. In principle, angels, better commercial terms, better valuation than VCs, but it's fair to say not always the case. That's probably a sort of a longer discussion, and something that, there's a lot of sort of pros and cons of each approach. If you are working with angels, then they are almost certainly going to be wanting to claim the tax reliefs. And there are two schemes that angels use. The first is SEIS, the Seed Enterprise Investment Scheme. That applies to the first £250,000 of angel investment that you raise from angels looking to claim the tax relief. So SEIS is the first £250,000. EIS, which is the bigger scheme, is the next 10 to 12 million, depending on what type of business you are. The way these schemes work, investor invests in your startup, and then they get back from HMRC as a credit against their income tax liability, a percentage of what they invest. Under SEIS, it's 50%. Under EIS, it's 30%. So if I invest 100,000 into your startup under SEIS, HMRC will give me half of that back pretty much straight away after I invest. There's a couple of other sort of reliefs that apply in these schemes, but the really big one that I'm just going to touch on is a tax-free exit. So I invest under either of the schemes. I have to hold the shares for at least 3 years. When I come to sell the shares, I pay no tax whatsoever on any gain that I make, as long as I've continued to comply with the rules of the scheme and the company has as well. So you're giving a tax-free exit to your investors. That's totally uncapped. So we had a client last year who sold an FMCG business for about 120 million quid. There was an investor in that business who'd invested about 500,000 under a mix of SEIS and EIS. He sold his shares for £12.5 million, 100% tax-free. So if you are an angel investor, that's obviously what you're trying to achieve. And these schemes are very, very attractive. The way you qualify is you basically make a submission to HMRC to confirm that the business you're carrying on is carrying on a qualifying trade, and that you're going to use the investment money in a way that is compliant with the schemes. There's a process called an advanced assurance process. It's not mandatory, but in reality, you probably have to do it, if only because investors will want to see the confirmation from HMRC that the company does indeed qualify for the rules of the scheme. Most businesses that are selling food and beverage products are going to qualify for these schemes. So that's the good news. The trickier bit is figuring out on what basis you want to qualify. And very simplistically, there are two routes. You can qualify for these schemes as a retailer or a wholesaler. That's the easy route. Basically, are you selling a product? Yes. Or are you selling a product under your own brand? Yes. Basically, you qualify. The second route is to go down a little bit more complex. So it's a product creator who's creating significant research and development. So you're creating, you're doing innovative stuff. You're doing lots of R&D. That route is often better if you're doing something, or if you expect that you may need to keep raising investment beyond the first 7 years of trading. So EIS, you can only claim those tax reliefs for 7 years after you commence trade, unless you fall into one of the extension conditions that allow you to extend that period of time beyond the 7 years. A business that is simply a retailer or a wholesaler will only be able to raise investment under EIS for 7 years from commencement of trade, unless they enter a new geographical market, in which case they can potentially extend a little bit beyond the 7 years. But if you are doing a lot of R&D, you're creating a new type of product, then potentially you can become what's called a knowledge intensive business, and you can extend through 10 years, and then actually potentially beyond that if you enter new geographical markets after that point. So it is better if you're going to do R&D to qualify as an R&D business rather than just a retailer. But it is something that you need to think about up front, because if you don't talk to HMRC about it now, you may be precluded from going down that route in the future. So if you're going to do a lot of R&D and this is a really innovative new product, talk to a lawyer. By all means, book a call with me just to think through that little bit of nuance, because it's something that's worth picking up at this early stage. Valuation methodologies are very, very complicated, lots of weird and wonderful stuff, but if I can just distill it down to a couple of points. Your valuation dictates the percentage of the company that your investors will hold. So if you are raising £100,000 at a pre-money valuation of £900,000, your investors will hold 10% of the company. So 100,000 divided by the post-money of 1 million, 10%. So what you need to figure out when you approach investors is what your valuation is. Your valuation technically comes off your financial forecast. So generally, the way we're looking at valuations of early stage businesses is we're looking at your revenue or profit forecast 24 months after the investment round closes, and we're applying a multiple to those numbers, and that gives you your valuation. So what you shouldn't be doing is saying, I want to raise it 2 million quid. And then we look at your financial forecast and we see that 24 months after the investment round, you've got £3,000 worth of revenue. It's just not going to support that level of valuation in most circumstances. So there's a lot of linkage between the forecast and the valuation, and you really need to understand that and get that right. It's also worth saying though, forecasts are forecasts. They can be crazy, they can be conservative. As well as putting together your sort of best case realistic forecast, you do need to look at other factors. So the two factors I would flag: one, comparable businesses. So if you are selling jams, and assuming you're not Meghan Markle, you're selling jams, look at other businesses who started out selling jams. What were their valuations? How much revenue did they generate in the first couple of years? What are their valuations today? You know, where's their profile? What sort of happened? So use that comparable to try to educate your own financial forecast. And then the second point is be aware of investor expectations. Early stage angels do not expect to invest in a food and beverage business at 100 million valuation for the first round, because it's way above market, it's massively high. If you go to angels with that sort of valuation, they're not going to talk to you. So have an understanding about the kind of valuation that your investors will expect, and sort of try to sort of be broadly within that ballpark. In terms of process, conceptually fairly straightforward. So you identify your investors, you pitch to them, they like you, they get excited. You then give them, or they give you, a term sheet, which is a 2-3 page summary of the terms of the investment and the terms of the investment documents. Once that term sheet's agreed, then the long form documents are drafted: shareholders agreement, subscription agreement, new articles. Once that's done, money goes into your bank account, shares are issued, everything is sorted. You now have investors in your cap table. Conceptually very straightforward. There's a lot of complexity in the middle of it, but that's really the sort of process. How long does it take? It depends on the investor. It depends on how long it takes you to find them. But from the point the term sheet is signed, somewhere between about 2 and 6 weeks is pretty standard. Longer if you've got lots of investors, perhaps working with a bigger fund, you know, those sorts of things. Shorter if you've perhaps got one early stage fund or one angel who's putting the money in and they kind of know what they're doing and it's nice and straightforward. So final section then, selling the pie. I don't know about you, I am ready for a bit of pie, to be honest. This pie particularly looks very tasty. So the first topic I wanted to just touch on was consumer documentation. So if you are selling through your own website, or you're selling through, you know, direct to consumer through Amazon or whatever it might be, there are sort of some basic things that you need to be getting right. The first one is your terms of sale. So if you've got your own website, you've perhaps got a Shopify platform, you're going to have T's and C's. So these are the contract between you and your customer that set out the terms of what they are buying and how they are buying it. So the key things to think about here are things like limitation of liability. So what are you liable for? So let me just give a silly example. Let's imagine that you are selling cakes, right? You're doing a bit of personalization. So you're putting happy birthday on them, or, you know, happy honeymoon, whatever it might be. I suspect that people are going to order these things with a very specific date in mind. So they need the birthday cake by the 28th of August because they're having a birthday party or it's kiddo's birthday. In that circumstance, if you deliver it late, there's a reasonable chance you're not going to get paid, or you're going to be asked for a refund, and potentially somebody who's really upset may try to take a pop at you for destroying the life of their poor child who didn't have his birthday cake. So think about what can go wrong. Think about what limitations of liability you need to include. Similarly, on commercial terms, normally this stuff is pretty straightforward, but if there's anything weird about your product, or you're trying to do something slightly different, make sure that it's absolutely clear to your consumer customers what the terms are. When you sell to consumers, you have to comply with consumer laws. So there's all sorts of different things that apply to you, and you need to be familiar with them, and your documentation and your process needs to be compliant. So the key things to think about tend to be return policies. So If somebody buys something through distance selling, so they are not buying it face to face, by default, they have a right to return that product, so to ask for a refund. Normally, with consumables, you would exclude that right of return. Well, normally, you might want to exclude it if the product effectively is going to be damaged or ruined or incapable of being sold once it's been delivered to the customer. But there are things like bottled drinks, for example, that potentially there would be a right of refund, a right of return. So think about that for your product. Do a bit of research if you need to, and make sure that your approach is compliant with the law. The second thing is around disclosure of information. So, there are obligations to disclose different bits of information in respect of different products. So thinking about allergens, the labeling stuff we talked about earlier. So you do need to get that right. And then finally, don't forget data protection compliance. It's something that in the food and beverage space often does get missed. So if when you sell your product, you are collecting people's email addresses and you're going to add them to a mailing list, which by the way, you shouldn't be doing without their permission, but let's just imagine you are, you need to have privacy policies in place. You need to have compliant privacy notices. You need to have mechanisms to allow people to exercise their rights, so their right to ask for a deletion of their data. All of that stuff needs to be done. And I would say to you, it's super important if you're a B2C business, because when dealing with consumers, the ability to market to them, the ability to keep in contact with people who bought stuff from you before is really important. And if you don't have the right data protection documentation in place, then you shouldn't and really, well, you can't do it and you shouldn't be doing it. So really try to make sure that's right as well when you start trading. On the B2B side, I wanted to talk briefly about distribution and wholesale agreements. So for many of you, these are probably the thing that you're most excited about because you want to get into supermarkets and you want to get into big distribution networks. Goes without saying, these are massively important documents. When you come to sell, your buyers are going to be looking at these agreements and they're going to be attributing the vast majority of value to them. So it's important that they are well, as good for you as they can possibly be, but that they're not, that either that they don't have really negative and problematic provisions in them, or that you understand what they are and where they are and why they're there. So the key things that I would suggest you should be thinking about, obviously pricing, but more importantly, payment terms. So with big supermarkets, you'll find that the payment terms are long and some of them are really bad at paying. So we have clients in this space who are in effect on 90 and 120-day payment terms. If a big supermarket, so let's say in your contract you have 30-day payment terms, and a huge supermarket who makes up 40% of your revenue pays you on 120-day terms, I can tell you right now, there's not much you can do about that. So you need to try to understand not just what the contract is going to say and try and bring those numbers as far down as you can, but also understand how the supermarket behaves or how the distributor behaves. If your advisors, who hopefully are pretty familiar with these people, say to you, look, it says 30, they never pay less than 120. If you push them too hard, they'll just terminate the contract. You need to know that, because you're going to have to provide, you're going to have to deal with cash flow support and potentially borrow money or whatever it might be to fund that cash flow gap. On the other side of it, you need to understand the penalties. So you'll very often find in distribution agreements provisions that say, if you are late in delivery, if you can't deliver the right quantities, then there are penalties imposed. Now, we would always say, try to get rid of that kind of stuff as best you can, but sometimes you can't. Sometimes it's just a condition of the distributor. So being aware of that financial stuff is super important. Connected with that, understand your obligations. Some distribution agreements are infernally complicated, and there are tons and tons of obligations, some of them obvious, some of them really quite obscure and bizarre. You do need to understand this stuff. The obvious things are delivery timescales. When the distributor makes a request, they're probably submitting a purchase order and they want 100,000 of the product. What are your timelines to accept that? Is it a day? Is it a week? And then when do you have to deliver? Do you have to deliver 10 days after the order is accepted, or do you have a bit of flex about how long that is? If you have to deliver 10 days after you've accepted a purchase order, bluntly, you don't have the time to go to your manufacturer and get those products manufactured. So you probably need to have products sat in a warehouse somewhere. You're not going to want to have huge amounts of products sat in a warehouse just in case somebody orders. So that would say to me, if you're agreeing to a tight delivery timescale, you need to have regular updates from your distributor about how many products they've got in stock, how many they're selling, what their expectations are, and all of that stuff needs to go into the contract. Exclusivity. So sometimes distributors will say, we want our product to be exclusive to us. Do we want your product to be exclusive to us? Full stop. Perhaps exclusive to a particular area. We don't want you selling to other retailers in this particular town, maybe within a particular category. So exclusivity, generally, in my view, really bad idea. You want to avoid it where you possibly can, because it limits it limits your ability to grow your business. If you're going to agree to exclusivity, then ideally you want to tie it to things like minimum order quantities. So sure, we can be exclusive if you're selling 10 million units of our product each year. We're not going to be exclusive if you're selling 20 units. So tying it to minimum order quantities, tying it to revenue, tying it to marketing spend. There's lots of things you can do to minimize the effects of exclusivity arrangements. And thinking about that is really important. And then finally, term and auto renewals. My observation from doing this for way too long, longer terms are not always a good idea. So you might think to yourself, well, we are signing a contract with this fantastic, wonderful supermarket. We want this contract to be as long as possible, because the longer it is, the more revenue we make out of it. Not necessarily true if they don't have minimum order quantities. So if basically you've got a contract with them that says, I don't know, they'll order as they want, and the order quantities going through the system are 1,000 a month, and for you that's very small, actually you may not want to be in that contract, because you are working with XYZ supermarket, you may find that another supermarket won't work with you. So think about term, and I would say particularly be super careful about auto renewals. The number of times clients have had auto renewal terms in their contracts. So in other words, at the end of the initial term, it auto renews for further terms of a year or 2 years or 3 years. That they've had those provisions in place, they've forgotten about them, and they have been seriously upset when they've auto renewed because it hasn't been a good contract for them. So be very careful about term and auto renewals, and sort of think about how that will work for you. Outside of the contract, the things to think about, I think when you're looking at distributors and looking at wholesalers and supermarkets and all this kind of stuff, the couple of things I would say you should just have a think about. The first one is funding the expansion. So it's all very well signing a contract with a distributor. If it goes well, they are going to order lots and lots and lots of product from you. And in all likelihood, they're going to want you to deliver that product pretty quickly. Going from 10,000 units a year to 100,000 units a year is a massive step change. And that's going to cost you money. You're going to have to fund that expansion. In all likelihood, it's not going to be funded by a distributor, because they're probably paying in arrears. So you need to understand before signing these agreements how you're going to fund the scale up. Maybe it's a loan. So maybe it's a loan off the back of the distribution agreement. And if you've been in trade for a while, that's actually a really good way of doing it. If you're a bit earlier stage, it may need to be equity investment. So think about how you're going to fund it. The second thing is think about supplier defaults. So, every so often distributors go bust. If they go bust, you risk having a chunk of, or a load of product sat in their warehouse. In an ideal world, your distribution agreement has a provision that says products in their warehouse that they haven't paid for belong to you, and those are called retention of title clauses. That's definitely something you want. You may not always be able to negotiate that. Even if you have a retention of title clause, the problem is going to be getting hold of that product. And what you often find when a company goes bust is the liquidator spends a disproportionate amount of time trying to figure out what the hell has gone on. And if your stuff is stuck in a warehouse that is owned by the insolvent company, you can't just go to the warehouse and get it. And it might take a month or longer for the liquidator to actually figure out that this is yours, by which point the products are ruined. Maybe they haven't been refrigerated properly. Maybe they've gone past the sell-by date. So think about supplier defaults, and bluntly, it's worth getting insurance for this kind of stuff. And the final point when thinking about distributors is actually around reputational impact. So not all distributors are good distributors. So, you know, if you are saying to yourself, we are a high-end product, we are a premium product, and let's imagine you're in Selfridges, your aspiration is you want to be in Waitrose. There are supermarkets you would not want to sell your products in because they're not aspirational, they're not premium, and it potentially would be off-putting to Waitrose and other sort of premium retailers if you're in there. So think about this a little bit more strategically. Just because a supermarket is prepared to work with you doesn't mean that's a good idea. And so sort of, yeah, thinking that stuff through. Final topic then, before we move on to any questions, is around selling the business. We're a long way from there, and so I'm not really going to go through the process of a sale and all that kind of stuff. What I really just wanted to touch on is the things that you can do today or think about today that will pay you dividends when you come to sell the business. So the first thing is sort of preparing for sales. So when you're at the point of going to sell your business, there are a couple of things that will be important to you. The first is that you've got the right type of revenue. So we're thinking about contracts with distributors that are that are solid contracts, that you have regular order quantities going through them, and that you can sort of show to a buyer that this is a contract that there's no reason for it to be terminated. It's going to do really well. You're thinking about revenue that is based on a decent profit margin. That's the kind of thing that you want to think about. At the early stage, it's probably true to say that any revenue is good revenue. Any revenue is good revenue. But do just be aware of the types of, what is better revenue at the point of sale, and as best you can, think about how you can sort of line that up. When you come to sell, you do not want, in most circumstances, to have your revenue sat with disproportionately with one or two distributors, because if they were to terminate for whatever reason, a huge proportion of the value of your business is lost. So what you want to try and do as best you can is spread revenue across multiple clients and customers. As I say, at the beginning, it's probably not so relevant, but do try to get that fragmentation across your customer base as soon as you can, because it protects your revenue streams, and it protects your sale value. And finally, try to be aware of contractual provisions that are problematic. So change of control clauses. So in allowing a distributor to terminate if your business is sold, it's hugely problematic. Buyers will very often say, well, we're going to treat that contract as having zero value. So think about those things today, because those contracts could still be in place in 10 years' time and could cause you a problem. In terms of the buyer, it's worth thinking today who your buyer might be. So is it going to be, is it going to be an aggregator who's going to buy your products? Is it going to be private equity? Is it going to be, a supermarket? The reason it's important to understand that is it potentially impacts how you grow the business, who you work with, how you price your products, all those sorts of things. So just try to have a think about that. None of us have a crystal ball, so you can't guarantee where you'll go, but think about those things because they can impact on how you grow the business today. I'm going to stop there. If you've got any questions, then you're welcome to ask them now, pop them in the chat. If any of you would like to book a call with me to run through any specifics with you, or on anything we talked about today, or indeed on anything else that's relevant to you, you can scan that QR code and book a call with me directly. You can also pop an email to us at any point, and we can set up a call. Cool, Ivan. Do we have any questions?
Yes, hi everyone. Thanks so much for the very insightful presentation. Mike, actually, we did receive a few questions in advance from people who registered to Eventbrite and Meetup, so I'm going to read those questions. And the first question is on how is the best way to get into supermarkets?
So yeah, it's the question we get asked all the time. So the easy way to get into supermarkets, if it's probably the right way of putting it, is to work with an advisor who's familiar with the space. So there are some excellent sort of consultants and advisors who work in this space, and they really do have a very good connection with the buyers, various different buyers in supermarkets. The word of caution on this would be you need to really do your research on consultants and make sure that they know the buyers in your particular category of product. So supermarkets don't just have random people floating around who will look for jams and also look for beers. They have specialists who focus on a specific niche. Your product will have the potential. It could fall into a couple of different product categories. And there's a lot of thinking, by the way, that goes on behind the scenes into which product category is best for your business. That sort of stuff can be handled by consultants, and they can add a huge amount of value. And you want to make sure the consultants you choose are people who are familiar with your sector and your category and can genuinely introduce you to the right people at the right supermarket. If anybody would like referrals or suggestions for consultants, then again, ping me an email. There's a couple we work with who are superb. Very happy to make an intro.
Thank you, Mike. We also have another question. How should we pay incentivized advisors and food and beverage consultants?
Yeah, so it's a good question. There's sort of a couple of ways of doing it. So you can pay a day rate. So a lot of consultants will offer a day rate. That can actually sometimes be a really good way of doing it. And my experience is that some of the better consultants will do a day rate simply because they're in huge demand and getting people to pay a day rate is a way of ensuring that there's a sensible value exchange. So that's one option. The second option is sort of an equity. It's often a mix of cash and equity. On the equity side, what I would say is they should only be earning equity for genuine value delivered. And I think the really difficult thing with equity deals is they tend to be based off an implied day rate. So you sort of say XYZ advisor is going to get, I don't know, 5% to the company. It's going to be based on a deemed day rate of £1,000. And that's going to be sort of accumulated up, and we're going to sort of treat the relevant amount of shares as vested at the end of the year. There's nothing wrong with it. My only caveat on this would be, in my experience, the really good consultants tend to charge cash. The people who think they're really good but are not necessarily quite as good tend to do the equity deals, and that's an incredibly unfair thing to say, but it is sort of my experience on it. The problem with equity is they're not getting cash. I know it's a really obvious thing to say, but consultants tend to prioritize the people paying them cash, right? And if you've got somebody on an equity deal, they're going to be focusing on the cash clients first and not on the equity clients first. So I think be careful of equity and try to make sure, if you do an equity deal, that you've got a really objective mechanism for measuring value and that you can get out of it if you don't feel that value is being delivered.
Perfect. Thank you, Mike. I'm going just to read two more questions. The next question is, what value should they be raising investment at?
Well, so it depends on your business, right? So it's that point about sort of those forward-looking forecasts. So you sort of look at you do your financial forecast, look at where you think your revenue or potentially profit will be in 24 months' time, and then apply a multiple based on your specific sort of sector and segment to that. I mean, as a rule of thumb, and I hesitate to say it because it really does vary by product classification, but roughly first round, you're probably looking valuations between, I don't know, 1 and 3 million. That's roughly where the market is. But yeah, it's very much based on your specific business.
Thank you, Mike. And the final question is, can I sell products at different prices to different retailers?
The answer is yes, of course you can. You want to be a little bit, there's a bit of strategy in this, right? So different retailers will squeeze you more on cost. So the classic example, Tesco, they are quite aggressive in terms of cost and they'll really, really squeeze you. Some of the other supermarkets are not quite as bad. So it might be that you end up with a product in Tesco where you're selling it at a significantly lower price to them than the price you're selling it in, I don't know, XYZ other supermarket. The thing that you just need to be a little bit careful of, and I think is the sort of the important point, is you want to make sure that the products are being sold by the retailer at the same price across, or broadly the same price across different retailers. It can be very difficult for a brand when you've got markedly different prices across different retailers. It happens all the time, right? If I go to Waitrose and I want to buy a packet of biscuits of a particular brand, it's likely to be more expensive in Waitrose than it is in Asda. So it does happen, but I think it can cause problems for brands. And I think you just need to be strategic about this and just think about implications and whether or not you want to regulate the sale price of the product by the retailer.
Perfect. Thank you so much, Mike, for your time. If you don't have any questions, we can conclude the session here. As Michael mentioned earlier, if you have any questions, follow-up questions, you can always drop him an email or organize a free consultation. In the chat box, I also shared Michael's contact details and his calendar where you can book a free health check for your business. It's 30 minutes consultation. We'll be sending the slides from the presentation tomorrow to everyone, and also the video recordings will be available on our website in the next 1 or 2 days. So make sure that you check our insights page if you want to watch them again. And in the chat box, I also shared our next event. It's actually tomorrow. It's in collaboration with the City of London, and the topic is intellectual property. Michael touched based a little bit on that at the beginning of the presentation, but if you want to get a better insight and deeper insight of trademarks, intellectual property, how to protect it, what you need to look for, feel free to register and join. The event is tomorrow at 2:30. And feel free to follow us on social media. We always share lots of insights and articles, everything that is relevant to startups and food, hospitality, and beverage businesses as well. So thanks so much for your time, and we hope to see you at our next event. Bye-bye.
Bye-bye.